And we also have a presentation from the Rhode Island ACLU. Steve Brown will discuss recommendations for improving civilian oversight, transparency, and accountability. So Steve, are you there?
I am. Oh.
Yes, please. Yeah, please proceed. Thank you.
Can you hear me?
Yes.
Okay. Thank you very much. Thank you, Senator, for inviting me to testify before this task force. This really is a very important and timely review. As you indicated, I was asked to focus specifically on transparency issues and accountability issues. We agree with a number of the other suggestions and recommendations have been made, but I'll focus my few comments on transparency. And in talking about transparency, I think it's critical to recognize that you can't just look at LEOBOR, you also have to look at how it interacts with the Access to Public Records Act. So I'm going to talk about that for a little bit as well. In terms of LEOBOR itself, there's really only one section in the statute that deals explicitly with transparency. And that's a section that Mayor Elorza referred to, which limits the public statements that police departments are able to issue when there's an ongoing disciplinary investigation. We agree with what the mayor said about giving police departments more leeway to talk about these issues, even if in a limited capacity. A complete ban on speaking really does create issues of trust in the community when there's no response whatsoever coming from police departments after significant issues occur. But there's also a second issue with that portion of the statute. It's led to a lot of confusion over the years. The prohibition on public statements has sometimes been read to prohibit the release of documents related to the case. We don't think that's what the statute says, but in making amendments to LEOBOR and making amendments to that particular provision in the statute, we would encourage this task force to look at clarifying the limitations of what that restriction covers so that it does not involve records as opposed to public statements. And that brings me to the second and major issue for us about transparency and how LEOBOR interacts or doesn't interact with the Access to Public Records Act. Across the country, you are seeing incredible efforts at promoting transparency in police departments. Just this past month, Suffolk County DA Rachel Rollins released a list of police officers who have what they call credibility issues. The Berkshire County DA did the same thing just the other day. New York State amended its open records law to make all disciplinary records of police departments public. Literally hundreds of thousands of records have been released, and the records that go into detail. They have the name of the officer, what they were, what the charge was, whether they were disciplined, and what the discipline was. And this is a trend occurring across the country. But here in Rhode Island, the lack of transparency is really overwhelming from our perspective. We're battling being able to get misconduct records, even when the information, identifiable information about the officers is redacted. Never mind trying to get information with the names of officers. And I just want to give a very brief legal history about this. The ACLU was involved in the first lawsuit over the Access to Public Records Act back in the 1980s, and it involved police records. There was a Brown University student newspaper that sought to get records from the Providence Police Department of all of their final investigations of police misconduct. What was the final result of complaints that had been brought to their attention? The police department fought that open records request all the way to the state Supreme Court. And the state Supreme Court issued a very important ruling and said the newspaper had agreed to redact any personally identifiable information about the officers, and with that caveat, the information should be public. We had the same battle in the 1990s, again with the Providence Police Department. Again, the state Supreme Court issued an opinion saying these records are public as long as they're redacted. Unfortunately, what's happened in the past 6 or 7 years, that opinion has been eroded. It started with some attorney general opinions 6 or 7 years ago that began making distinctions between types of final records of police misconduct. So an AG opinion from 5 or 6 years ago said that there might be a distinction between records that of complaints that citizens have filed versus internal investigations of misconduct of police. More recently, an opinion that delved into it further held that every final record of police misconduct has to be examined on an individual basis to determine whether it should be released, even in redacted format. And a Superior Court judge just a few months ago agreed with that interpretation of the law and refused to release to a public accountability project these final records of police misconduct that we had thought were clearly public under these earlier state Supreme Court decisions. So we're involved in litigation with that right now. I know the ACLU and the Attorney General have a strong difference of opinion about exactly how to interpret the open records law provisions regarding with police records. I guess all I would say is whichever version you believe, the fact that even redacted information about police misconduct is not automatically open should be of great concern. And we strongly believe that the Access to Public Records Act provisions governing access to records dealing with police really needs to be amended to address this issue. We believe it should go further and allow for releasing the names of officers under particular circumstances as well. The one other issue of transparency I'll raise, because again, this is something that we're seeing occurring throughout the country. It's also something that we also recently had correspondence with the Attorney General about, has to do with public access to police body camera footage. I know that's something that Mr. Batista has been dealing with as well. There's an issue in Providence where a police officer was allegedly assaulted somebody in his custody, and there have been difficulties making that that body camera footage public. We would encourage the task force to look at that issue as well and set some legislative standards on the release of body camera footage to the public. I think it's really important in terms of promoting transparency. We saw in the Daniel Prude case, which was the young man who died in Rochester, New York. There was body camera footage that the police department refused to release for months, which showed exactly what had happened, and it just created enormous distrust in the community, understandably so. And to the extent that the legislature can get on top of that, I think would be very helpful. Right now, there are only a handful of police departments that use body cameras. We know that's going to be expanding. So we would encourage this task force to look at coming up with standards, and we'd be glad to work with the task force in doing that to prevent disputes over access to this very important footage. And we think with those sorts of changes, there will be an incredible increase in trust between the community and the police departments. All that secrecy does is encourage questions, concerns about people hiding things, even if they may not. So we hope that in addition to all the other recommendations you're considering on other matters related to LEOBOR, you'll look at this issue very closely too. With that, I'll be glad to answer any questions.
Yeah, thank you, Steve. Any questions for Steve Brown, Mr. Brown?
I do, Mr. Chairman. Tony Capezza.
Yes, Tony, go ahead.
I just wanted to clarify something that Mr. Brown said. Did you say that these cases have already gone to court and the courts have ruled on the request?
So there were 2 state Supreme Court cases that we've relied on over the decades. The rate case and then a case involving DARE, Direct Action for Rights and Equality, where the court held these final records of police investigations of misconduct, if redacted, are public records. We're now involved in a pending case in Superior Court in which the court said that it's not as automatic as we believe the open records law and these earlier Supreme Court cases say they are. And the court has said that the records need to be examined individually. So that is pending. It's the other cases that were decided many years ago that we're relying on to say that these records should be public if they're redacted.
Okay, thank you.
Any further questions for Mr. Brown? Any further questions? Well, if not, I just want to make the commission members aware that I've received numerous. Oh, I'm sorry, Reverend Jenkins, you had a question. Let me back up.
Yes, I just wanted to thank Mr. Brown for that report. Thank you for the insight.
Thank you.